Roshan sir, are you there? Just acknowledge. Yeah.
Yes, sir.
I think the session started. Niranjana ma'am, you can proceed.
Okay,
Niranjana ma'am, proceed, please.
Yes, ma'am. Education is not just about going to school and getting a degree. It's about widening your knowledge and observing the truth about life and being competent in the field of competition. As said, you don't have to be great to start, but you have to start to be a great. I am Niranjana, Assistant Professor, Department of Electronics and Communication Engineering, SVCE. It gives us a great pleasure to extend a very warm welcome to everyone on behalf of Sri Venkateswara College of Engineering and Department of Electronics and Communication Engineering for the splendid event organized by IIC Cell and R&D, SVCE in association with Department of ECE. In this occasion, we thank specially to our management, IIC Vice President and Principal Dr. Nageshwara Gupta sir, IIC Convener Dean R&D Dr. Nirmala Gupta ma'am, Event Convener Head of the Department Dr. Jijay sir, Dean Academics Dr. Purnima ma'am, and our Register Professor Prakash sir for motivating and supporting this great event. We are so grateful to all who have accepted our invitation to be the part of this elite event. Thank you very much. Honorable CED sir, respected Principal sir, IIC Coordinator, Head of the Electronics and Communication Department, Head of various department professors, most valued participants, and my dear colleagues. It is my great pleasure and privilege for me to welcome you all for this IIC Cell and R&D SVCE in association with the Department of Electronics and Communication Engineering, organizing a workshop on IPR and IP Management for Startup. We are honored to have Dr. Roshan Zamir Ahmed with us today as a resource person for this event. I take this opportunity to welcome today's resource person, Dr. Roshan Zamir Ahmed sir, Assistant Professor, Department of ECE, MSRIT. On behalf of SVCE Management, Principal, HOD, IIC Coordinator and staffs of ECE Department, I cordially welcome you, sir, for this workshop. Our ever-driving force, Chief Executive Director, Dr. N. Sashidhar, sir, and Principal, IIC Vice President Dr. Nageshwara Gupta sir is always there with us, encouraging all our endeavors and also giving new ideas and dimensions for all fresh activities in this institution. Due to sir's pre-compelling work, sir could not attend this session. However, sir has conveyed his best wishes to all of us. Next, we have our respected Dean ma'am, Dr. Purnima ma'am, who is strength behind all of our activities. It is with her support we have arranged this workshop. Next, I take the opportunity to welcome Dr. Nirmala Gupta ma'am, Coordinator, Dean R&D, IIC Cell SVCE. We cordially welcome you, ma'am. Next, I take the opportunity to welcome Dr. Jijay sir, Head of Electronics and Communication Engineering Department, SVCE. We cordially welcome you, sir. On behalf of all, I wholeheartedly welcome you, sir, for today's workshop. Finally, but not the least, I welcome all head of the departments, coordinators, faculty members, students, and participants for this workshop. I request our very enthusiastic Dean, Dr. Purnima ma'am, to talk few words and enlighten us.
Very good morning. I'm happy that IPR Cell and our Department of Electronics and Communication Engineering both making this program. On behalf of management, Principal sir, I cordially welcome Sami sir. And earlier, the way back, maybe 5-6 years back, he was our student, and now he is an alumni. And I cordially welcome you. And this particular innovation, IPR, intellectual property rights, and its awareness, it has been conducted for all the semesters. Since the reason behind it is that still our India, it is nurture a lot in innovations. and it has to give a path for many startups. The IP cell, it is enthusiastically, they are conducting such events, many in number. And dear students, you please make use of this program effectively, and please ask your questions, queries with our resource person, Zamir Ahmed, sir. Okay, thank you. I wish you all the best.
Thank you, ma'am, for your motivating words. Now I request our lovable and supportive head of the department ECE, Dr. Jijay sir, to talk few words.
Very good morning to one and all present here. I am very much thankful to Dr. Roshan Zamir Ahmed for accepting our invitation and being part of this event. And very much thankful to Principal and Dr. Nirmala Gupta Madam and Registrar and Dean Academics for being part of this event. And all the students and faculty members should make use of this knowledge on intellectual property rights and IP management for startup. So really, see, it's a dream for any individual to have a startup of his own and to drive almost 10 to 20 employees as a small scale industry or something. So to get a small idea as a backup is always a great pressure for an individual to start something innovative. So it's always very important for us to go with an IP filing and going with knowing the protocols or how the process works out. So it's a great opportunity to hear all these things from Dr. Roshan as part of this program, and it really helps all our students and faculty members to come out something innovative in their mindset, whatever it is there, and drive something new as part of their career, and which will help them to do something better as they are into the regular routine. So I request Dr. Roshan to just look into all those aspects and motivate our students and faculty members so that they can think something beyond what it is they are usually practicing as of day-to-day basis. So thanks a lot for being part of this event, and I request all the members to make maximum utilization of this event to the best extent. And if any request required for IP management or for startup or anything, I really request all the participants to ask questions and make it more productive. Thank you.
Thank you, sir, for your supportive words. Now I would like to hand over the session to Professor Prakasha, Registrar, to provide a brief introduction about our chief guest, Dr. Roshan Zamir Ahmed.
Good morning, everyone. Am I audible?
Yes, sir. Yes, sir.
Hope I'm audible. So, to introduce our today's spokesperson, Dr. Zamir Ahmed. So here is a brief history. His qualification is basically from Composite PU College, and he's the of Venkateswara College of Engineering, where he did his BE in Electronics and Communication Engineering from 2007 to 2011. From 2011 to 13, and immediately he has started his doctoral. He has completed his. He also did his MBA, Master of Business Administration from St. Joseph College, and he has completed his MBA from 2021. And he has done a lot of activities. Here, one of the major achievement, what we can say, he has received a consultancy project from BIMS, that is Bangalore Institute of Management, towards a faculty training program and development and delivery of add-on courses in business applications. And it's a consultancy what he has received, and he has delivered many technical talks like he was a resource person for FDP in evaluation of e-powertrain performance and energy consumption capability in electrical vehicles. That is in 2012. Delivered a talk on impact of wireless sensor network towards the agricultural yield productivity at SVC itself. And he has also delivered a talk on IPR, one Bangalore Institute of Management Studies, that is building awareness and intellectual property rights, IPR, at BIMS. And also he has delivered a talk at Jain University about the IPR itself. And currently is motivating all the staff and students with respect to the and also IPR activities. He is also a associate member of IETE and also a member of IAA and two credits achievements. Very important is received a license to establish, maintain and work an amateur wireless station in India. Ministry of Communication, Government of India in 2019. And he has also a best outgoing student award in 10th standard. And I'm proudly say that one is one among the top 5 students during his tenure at SVC. And he has also published, till now, he has published 11 Scopus Index journals. And I would like to show one of his achievements. Just a second. Here is his credentials, Google Scholar. His citation till now it is 43. H index is 4, and also Ms. Ramaya College Institute of Technology. And we are very much as a resource person on today's event. I'm very glad and happy that Roshan sir has accepted our invitation to be the resource person. Thank you for accepting our invitation. Over to Niranjana ma'am.
Thank you, sir, for the brief introduction. Now I request our lovable chief guest, Dr. Roshan Zamir Ahmed, sir, to address the session.
Roshan sir, you can share the screen.
Yes. Am I audible and the slide is visible?
Yes, very much.
Yes, sir. Yes, sir.
Yes, sir.
Thank you. Well, good morning to everyone present here. Okay. Thank you for the introduction, Prakash. So today's topic I'm going to speak about is with respect to intellectual property rights and IP management for startups. So the presentation is divided into two aspects. Once we would be discussing with respect to intellectual property and its rights that have been associated, and with respect to the startup, what is the strategy and what are the government schemes that have been implemented with respect to IPR, and what are the which are by engineers who are currently available. When I talk about intellectual property, it's just a particular idea, it is just a particular incentive, it's just a particular monopoly right that is given towards an invention. So here, this particular right is being given from the government for a particular duration of time for a new invention which you have come in. So there is one inventive role as well as a monopoly right that is being granted. But who is responsible for carrying out all this particular operation? There's something called as World Trade Organization. This World Trade Organization is the main head, wherein there are so many such agreements that are being formed with respect to trade aspect. Now, one such trade aspect came with respect to what is called as TRIPS. TRIPS is the trade related aspect of intellectual property rights. Around 164 countries are associated with so what do WTO is as to what be done, what product, how many companies have, how should be the tie over, what about the licensing, what about the provocation, infinite, everything, each and everything will be by the World Trade Organization. In this World Trade Organization, there are so. Can you hear me? Am I audible?
Yes, sir.
Now it is okay, sir. You proceed, sir.
Yeah, so, actually, students. So the complete internet up down. So thank you. Now, World Trade Organization is the one where all agreements are with respect to every we decide organization. Now, moving ahead. When I talk about intellectual property, it is an intangible property that is not existing in physical form. It is just like some goodwill or some accountable or something like that. So this intellectual property, when I talk about, there are certain rights that are to be given with respect to the new incentiveness that has been brought about, and also for the innovation as well as the monopoly right that has been given. So what you can see down is the Thomas Alva Edison. He has done lot number of patents. One such example is, you can see there's a carbon telephone. On the right hand end, you can see this is called as a cartoon stretcher. The thing about this cartoon stretcher is it uses 166 stencils. Okay, that has been currently not being used anywhere. It was being used previously and it has been improvised to a greater extent. As I move ahead, you can see what I said with respect to creativity and with respect to monopoly right. There are so many things that have been introduced. India had a problem with this World Trade Organization in agreement saying that there are no such acts that have been introduced with respect to other such intellectual property. What are intellectual property? What are the rights that have been required? Okay, why did this come into picture is with this aspect. You can see there's a basmati rice on the left hand side. There is haldi in the center and neem. Is not. So there is one the partition. There was some amount taken to Pakistan. That basmati is coming from our side. Between India and Pakistan fight, automatically US took the lead, and a company Rice Duck, they filed a US patent telling in terms of Kasmati and Textmati that Basmati was renamed as Kasmati and Textmati, and they told that Basmati is exactly originated from US. When coming to haldi, we know that it is for medicinal quality and it is used for wound healing strategies and all. But it was being used by again US Patent Office, and it was being granted patent in the year 1995. Neem. Neem is used everywhere. It's used in toothpaste, it's used in emulsion, it is used everywhere. But when it was again used by US companies in 1992, and it was told that this was the one we have found out. Everything was Indian originated, but it was being used anywhere else. It was being used by US countries, it was used by Germany's. So India went with what is called as revocation of a particular patent in the International Patent Office. And finally, India got its own credit back. When all these things were looted, they requested the World Trade Organization to come with these particular things. That is your Copyright Act. They asked them to come with what is called as Patent Act. They asked them to design what is called as a Design Act, Trademark Act, Geographical Indication for Goods, Semiconductor Layout, and Plant Varieties. All these laws were designed by the World Trade Organization only on the appeal of India, because all the items were being taken from them and was being shown in a different way. When I'm talking about intellectual property rights, what is exactly the intellectual property? It includes, that is a new invention. It includes copyrights. Copyright contains your art, literature, music, broadcast, computer programs. Trademarks. Trademarks include your letter, number, logo, sound, smell.
Roshan, sir, slides are not changing.
Is it visible?
Slide is still in the second or third slide, I think so. Edison slide. Thomas Alva Edison slide only is there.
Here.
No, sir, it is moving. Types of IP is being there in the
Okay,
screen.
okay. No issue, no issue. I'll maybe from my end there may be issue. I'll rejoin.
IP. Is it visible?
Yes, sir. Yes, sir. It is visible.
Okay, thank you. So these are your intellectual properties. They have been categorized into 7 different parts. One is your numbers, logos, shape, pictures, all come under your trademark. Registered design, this are under your semiconductor shape design. It includes your chip shape design, mechanical design, all come under what is called as a registered design. Now there are new varieties of plants that are being incorporated. So they have something called as breeder's right, copyright, it's and are the which are become on patents today, and I'll give you a little limelight on other intellectual property rights. Coming to the first one, I told you that patent exclusive right granted for innovation. I say exclusive right, it is having a particular period of time. Now, after a particular period of time is crossing, okay, and there is no one to take over that particular thing, public. Government says that you make use of it. There is no one who's ready to take initiative of it. Right? So that is why it is called as an exclusive right. Anyone can use it after a particular period of time. Okay, and it is actually a process that provides some new way of doing things. So when you see a first particular example, Wright brothers did this particular sketch of the flying machine. When you go see glass, 49 by and still in you monopoly. And you go with there the first design person he introduced 99 and he still granted patent with that. So for India, what was the first patent when Britishers entered in? Okay, in 1856 there was George Alfred who wanted to have a particular patent that was being designed in India. In India, there was a particular machine which was called as Punkha. Correct. So it was used as a fan. So this particular fan design was being done by this George Alfred, and he patented it. And this was the first ever patent in India. Monopoly right has been given to this British as exactly where to cover should cannot be particular method, cannot be business profit as information not patable to is application oriented. That is required for a particular patent is novelty. That is, it should not be known to anyone. It should not be publicized anywhere, or there should not be any document that should be existing within or outside the country. Third thing, which deals with the prerequisites, is your non-obviousness. Non-obviousness is, say, for example, if I'm an electronics engineer and I'm working towards a result, whether attain, and suddenly, for my understanding, I was thinking that come called you position that you have got an ultimate result. So this is what is called. And finally, it has to be industrial application oriented. Now, this exclusion of non-patentability, it Article 27 agreement, the trade related aspect agreement for IPR, which exactly states that all naturally occurring substances you cannot go for patent. All your diagnostic, therapeutic, surgical methods cannot be biological process cannot be patenting. Okay, business ideas of where you're patenting, as mentioned before. Or patents are happening much. One thing is in automobile sectors, okay, in your telephony sectors, medical sectors, microwave sectors, computer areas, a lot of innovations that are happening day-to-day basis. Okay, as in technology is growing on a daily scale, correct? Now, a special requirement is you have to look, if you are trying to draft a particular patent, look for the application and look for this particular field, whether this is existing or not in terms of innovation. The second one is your disclosure. Whenever you're disclosing, as in when I'm going to explain with respect to patents, I'll be telling you what exactly is the disclosure. Disclosure is the list of all documents that are to be ready and that are to be prepared before you are submitting into the Indian Patent Office. So you can see, you will have on your right hand side 4 legal requirements to get the patent. First thing is your complete invention use, the eligibility criteria to be passed, the novelty to be checked, and the non-obviousness to be checked. So these are the ones which are the legal requirements that be checked from your patent point of view in the Indian Patent Office. Who are the ones who are into this particular race? That is your prolific innovators. We have Qualcomm, you have Philips, you have LG with 143 patents, Samsung with 111, Honda Motors 87 patents, Bosch with 39 patents, Limited with 37. So these are companies who will be looking for innovations, and when they go a particular patent, they take up the examination and finally make use of it in terms of monetary benefit, in terms of licensing, in terms of selling it, and in terms of getting investors as well. When you're seeing the patent trends from 2012 to 2017, the number of filing has fallen, and it slowly started increasing as and when the government scheme has been started, and the number of examination rates that are being carried out, then you have the granted one and how many have been disposed. Some people, what they do is, once they file a particular patent and they reach the publication stage, they don't take it further. They update their resume and they keep quiet, because patent takes 4 to 5 years of time. Until then, there is a new technology that comes in. Once you just file a particular patent, from then on your patent is being registered. If there is some other person also coming with a new technology, it will be your technology which you have been through, which you have the date of filing. This has to be kept in. Some people are like, they just file it and after it is being published, they leave it. No, this is a wrong way of doing things. So that is why government are coming with certain policies to see how many people have publicized it in the Indian Patent Journal, and they are going to individually write them mail to carry it further, or else the patent which is being displayed is disposed. So these are the steps which are going to be taken by the government in the coming days. The next intellectual property is your trademark. You can see all these logos like Make in India, Amul, Coca-Cola and all. What do they signify? They signify a particular service or a particular good registered trademark. And this registry will take for 10 years of time. After 10 years of time, again, it has to be renewed or it will be kept open for any person to take it over. Okay. Now, you can see there are certain examples. If Coca-Cola says in one of its advertisements that if you want my trademark, okay, my trademark is worth about 60 billion US dollars, and it is going to add reputation to your company, it is going to add valuation to your company, it is going to get investors to your company. This is how the whole trademark industry works, with the value and service what you provide and the venturing system which is being carried out ahead. When you go to any railway station, generally you take a Bisleri bottle. When you go to the railway station, you find the same Bisleri bottle in green color with the chance to be Billeri, correct? Now, the same way, Loka over here, Adidas is called Abibas, Puma is called Coma, Fuma. You can see McDonald's is called Munchie Burger. So these are the fake things that are being prepared, and people do not see to all these things, and they are being carried off and they consume it. Now, this is the bad name or deceptive similarity that has been caused with particular company, and it causes a downfall for it. So what the people do is they sue this particular organization who are carrying out all this. So you can see there are so many trade. So you need to protect your intellectual property right in this regard. That is why trademark is introduced. Now, as I told you previously, trademark comes with letters, numbers, colors, smell, logo, and stuff. So there are kinds of trademark on services, on certification mark, on well-known marks, as well as a trademark. You know, out lion road out. This is also which a part which have strawberry taste is what called as your smell mark. So these are all trade being given a particular mark. These are decent things they will for venture into agents. Okay, this is the same thing. Now, what are protected in the trademark? First thing is the whole company product, company is being protected. The economic benefit has been protected. If you trademark a particular product, it is like can be signed. But the state symbols or marks and all they not be trademark. Correct. Now, what exactly is the criteria for a trademark is you should see that it should not be used by any other means and spoil. It should avoid. And it should avoid misleading content to the public who have been using it. One important thing, what you can see is the trademark need not always be registered, but it can be acquired. What does it mean? It means that once a particular company comes with a logo and or a use a long period of documentation and the trademark registry. So at that time, if someone else is using, what's the main help? What it's saying. It at the time documents that as it was what it says. Now, functions of trademark I told you create business, brand awareness, product reputation, company, and also it's used as a tool for marketing. Now, I'll just show you a small case study. You can see on the left hand side, it deals with all your electronic gadgets and services. So, the center figure is a Sony nail polish, and the third is Sony glass, and the fourth image is having them. So, taking place around 1.5 or 2 years back. Wherein Delhi High Court had filed a case with respect to this, and the case was filed by the main Sony company, telling that Sony is being utilized for nail polish, it is being used for glass, it is used also for baby nail and all. Sony the damages with respect to the nail polish as well as the glass without taking price. But when you handle name, it has no relation with respect to electronic gadgets or services or something. So the case was squashed with respect to the name Sony with respect to this baby. You see the second case study, Mercedes-Benz. You can see this particular logo over here. Gujarat merchant to VIP Benz. The logo has been used as a deceptor, telling that it is from Mercedes. The and it doesn't sue at one shot, because as they sue on one shot, the opposite person will say that I do not have anything, I have not made business. Correct? So they will wait for a particular period of time.
Roshan sir, sorry
Yes,
to interrupt you.
Yeah.
Sir, just check the network bandwidth from your end, because I just requested 3 to 4 people from our end in the institution. The slide,
Okay.
what you are projecting is not mapping with the explanation. And if you are not able to see the slides, I think you unshare and share it once again, please.
Sure.
Okay, okay, sir. Thank you. Thank you very much, sir.
Yes. Now is it, ma'am?
Now it is visible, sir, very much. I think you can go for slideshow also. Thank you, sir. Thank you very
I
much.
think there is a problem from my end, because there is a central government exam that is happening and all the labs have been occupied. So
That's what I
bandwidth
was,
issue.
I was really checking,
Bangladesh-
is it from my end or institution end? And 3-4 faculty members also I cross-check.
Yeah,
Sorry
it's from my
for the
end.
inconvenience. And
No
thank you.
worries.
Thank you.
Sure. Yeah. So I was just discussing with respect to the case study too, that is Mercedes-Benz logo, which has been used by a Gujarati retail person for his clothing business. He just showed that an undergarment in terms of Mercedes-Benz logo, and he earned a lot of profit. So directly Mercedes-Benz didn't sue him. Okay, they waited for a particular period of time, that is 1.5 years time, and then sued him accordingly, and then gain the entire economic benefit out of it, and then the logo was being stopped, has been cancelled. Okay. Geographical indication. Geographical indication of one particular region. Okay, and it talks about one particular product of that particular region, which is very much famous. Now, exactly, you have Tirupati Laddu, correct? Now, you have Darjeeling tea. So these belong to a particular region. But can a particular single person be given a geographical indication right for this? No. This particular right is being given to or the users. Now, what you can see right here, you can see Kashmir, Kanga paintings, all belong for unit. A person cannot claim, a single person cannot claim it. There's a group of people involved. A group of people are being involved, or the group of one shot is that particular district becomes the first whole and soul towards the registry of that particular product, followed by the number of people who produced. Example, you as Darjeeling tea logo. Able to just like so from the image that word and here and this one that has happened in Chennai. But as the first users and second the group of who are involved in the exam. Example is I would like to give it over here. Now, example is over here. Say there is Darjeeling tea, correct? Now, this particular Darjeeling tea, if suppose the IPR right or geographical indication being right, first give it to Darjeeling. Okay. Now, this particular Darjeeling will distribute it right. How it goes. Okay. And Darjeeling tea cannot be cultivated in Nilgiri, and it cannot be called it as a Darjeeling tea, or it cannot be cultivated in Munnar. It cannot be called it as and it geographical indication or an IPR for its productivity. There are some more examples. You can see Kasar saris, you can see rice, you can see teak. So these are all geographical indications. You can see my Kullu shawl, Kanga tree, Orissa picket, all come under your IPR right geographic indication where there is no sole owner. First, the government is the owner for it, whichever area or whichever region belong to, followed by the number of producers who are involved. Now, if anyone is copying it and producing it in a different form, how does it happen? Section 39, if someone is selling in a false way, you can see and penalty for again selling it after given first warning is section 42. So there is an imprisonment of 1 year and it can be extended for at least 2 to 3 years with a fine of 1 lakh. So this is the punishment or violation if it is being carried with respect to geographical indication. Now, as I was telling you with respect to the registration part, there are two parts. One is part A and part B. Part A deals with the proprietor, that is nothing but the government, and part B starts with what is called as beneficiary or the people or producers who are totally involved. This is how the certificate looks like. On the left hand side, there is Hyderabadi Halim from Pista House. So you can see they have been registered under geographical indication, and you can see the certificate that has been issued. Next one is your copyright. Now, as I told you, copyright, it deals with all your lectures, it deals with your books, movies, it deals with maps, it deals with so many other things. One case study I would like to tell you over here is on the left hand side, you can see a person, he's a poet. On the right hand side, there's a lecturer. So there was a controversy that this professor has copied the poem of the author and later published in her name. There was a case which had been in your Delhi High Court, and it was towards the poet because later he had applied for the copyright. Once anything is being written or anything is being subjected and people know about it, automatically the person gets it. This is what is being done for IPR. Still can low of it automatically you have been given a right and register. Second case happened sometime in Delhi University, where there was the vice chancellor who had copied a part of some other student thesis, and it was being projected as his own thesis. Correct. So this was the case wherein he had to pay a lot of dues and other charges. So copyright has bundle of right, and it also may lead up to jail. This is what it says. Yes, this is the same thing what I discussed now. Yeah, you can see copyright also include certain lectures, work, your come under. Once a copyright is given, what is that? Having what is moral right and economic right is the authors pertain to this particular right, okay, and these are non-alienable right. For example, if a person approaches you, a publisher approaches you to write a particular topic, okay, and he is going to sponsor, so the copyright is being given to the publisher, okay, but you still remain as the author for that particular book. You, okay, the owner will be the publisher, but you still continue to be the author. So this is what is called as a moral right. Economic right is you respect to your economic rights. Yeah. Now, duration of protection, when you see over here, with respect to copyrights, there is some variation. As patent is given for 20 years, trademark for 10 years, geographic years, copyright will have certain variations. Now, if it is a photographic work, it is 25 years. If it is a book, it is 50 years. If it is any cinematographic work, it is again 50 years. So there is variation with respect to the different versions of copyright. Okay. The next intellectual property, it deals with what is called as industrial design. This industrial design is nothing but the surface pattern, the color pattern, the combination, okay, and the aesthetics that changes the complete appearance of a particular design. So you can see there are Tupperware boxes over here, correct? Tupperware boxes come with the same design, the same surfacing, correct? You can see the Coca-Cola bottle, the shape and size, the shoes shape and size, the complete sandals shape and size, the microwave oven, the shape and size, all are with respect to the design, the skeptical structure, all are being given a particular right, and it falls under what is called as industrial design. So this is also given for 10 years of time and an additional period of 5 years. So how to obtain an industrial design? There is Locarno classification. This Locarno classification is an internal classification done only for registration of industrial products. It is having 32 classes and is having 223 subclasses where objects are segregated and kept. Okay. Now, normally when you file the particular design, it goes with the examination. After the examination is being carried out, there would be a response that will be given with respect to objections. Objections are to be clarified. Once clarification is being done, you will be granted an industrial design towards a particular product, and you'll be waiting for a one particular month of time or 2 months of time, so that there is some other person who can come and file against as objection. Correct? If there is no objection from any of the third party sources, it becomes a long duration of time for you to carry out your industrial design with any product. The next thing is with respect to trade secret. Now, we have had this KFC chicken, we have Coca-Cola and all. Okay. There are so many people who are salesmen, and there are so many people who are into that particular firm, but they do not know the secret of a particular product. This is what is called as a trade secret. Now, Coca-Cola, the company, what it does, just gives a solution, okay, and goes to the vendor and says that just the proportion. That's all. And is nothing but it's called a trade secret. The same chicken, the masala that has been taken up, you never know what is that particular masala. It is then perforated across the particular chicken. And exactly is that particular masala. Now, I'm not talking only with masala ingredient. It also deals with the blueprints of a particular layout of servicing. It also deals with your market research studies, internal costing, yeah, custom list, management. All these which are not shown or not known to anyone is something called as trade secrets. You can see the New York Times as a secret. Still don't know that how many copies have been circulated. They still don't know that how many people have been using this. Is being set up. It is just a complete secret mode, and there is a right that is being given, which is called as a trade secret. The next one is called as a utility model. This utility model is similar to that of patent. So, say for example, I have a particular instrument. Okay, I show the design in another way. It's having the same principles, but show the design in another way. So I cannot claim it as a patent. It's called as a and utility model duration is for 10 years written by the government. So if there is an issue with someone to correct same structuring, but the whole pattern structuring or the is what as a utility model. Now, difference between a utility model and a particular patent. Patent has already inventive steps, application oriented, and requires the terms of production. Whereas utility model, it is just same, copy paste, but improvise it and show it in a different way. Copy paste, improvise it in a different way. So when you're improvising in a different way, also the use of technology. As we do research work and when we are doing some study or comparative analysis, we take the data what a previous person has done and we apply our own algorithm, changes in parameters. Okay, parameters, we obtain graphs. When do a comparison graph of our graph with the previous graph, we see so many changes happening. Correct. Now those changes only you claim that it is your innovative step that you have bought. The same thing is with respect to what is called as utility model. Now, what are these rights or what are these rights given and why are these being given by the government? Is it is not only with respect to unfair competition, but also to obtain investment funds or venture funds. This is what says to capture the human rights which are oriented in order to increase the GDP platform. And incentive function is the one because as someone is being rewarded. Okay, this is the government also planning to implement so many schemes in order to improvise the strategies in which I'm now. Before we start off with what is a patent drafting, patent filing and all, we have to one more understand what is called as PCT. PCT stands for your Patent Cooperation Treaty, to which 151 countries have been connected. Now they call it as 151 contracting states, but it is 151 countries. They call it as states. Here, what happens is if a person files a patent in India and he wants the same patent to be filed in Australia at the same time. He wants the same patent to be filed in Europe. He wants the same patent to be filed in US. Then he cannot just go and file in that particular country. He has to use one particular called it is in the PC publication, you do the international search and do the international publication and carry the same stage at national phase also. When you're carrying it at the national phase, that is in Chennai, the same filing procedure, publishing and examination. Very opposite to which your file this advantage. When you opposite countries at the same time of the national phase, it happens that your PCT application will be considered under utility patent that will be given for a duration of 10 years only. Okay, as and when the delays keep happening, there are so many people who would not interested in carrying it in a different country. It's going at a normal rate. What in for if through with non but it not be examination. When it is filed in India, first the international phase, international examination setup. This is what is called as an pay. Now is what we are going to start with our thing. First, you have an idea, presentation of this particular idea, draft particular application, and file particular application. So one of the things what we need is we need an abstract. This abstract should be of 250 words. The second thing what we need to have is we need to have what's called as claims. Okay, I'll come to that. We should have what is called as claims. These claims are either 2 to 6 in number, telling that this product of yours is going to reduce or going to increase certain things or certain parameters which you are focusing on. After that, you will have what is called as methodology, a particular block diagram, a particular flowchart. Now, once you're done with all these things, these are the necessary documents that you need to submit. But what are the forms to be filled? The forms to be filled are form number 1, form number 2, form number 3, form number 5. Form number 2 and file, when you give a DD of 1750 to the Indian Patent Office, you are given acknowledgement number. Keeping that acknowledgement number is your that has been filed. Provisional means it is incomplete. You do not have results with you. You are still going with a testing phase, or it can be changing at a certain moment of time. So after 12 months of time only, you have to file the complete patent. Okay. But sometimes what people do is in provisional patent only, they get it published by filling what is called as Form 9. So there are certain steps. I will just tell you with respect to this. Come over here. I'll come over here. Then I'll explain. The first thing what we need to do is we need to know about our invention, how it works, get the benefit, and so what exactly we should have? We should have an abstract, have that adopted flowchart and all things. Okay, you will take of 1750, fill all the forms and send it to the Indian Patent Office. Patent Office will go and check to see whether this is application oriented or not. They will publish it. It's no, it's like just they see it and they publish it. If they feel it is like not of subject matter, automatically they send a letter back to you along with your DD. Now, currently, if it gets published, okay, what is the next thing you people do is you ask for request for examination. When the request for examination has been carried out, then your report will be completely and thoroughly studied with respect to all aspects, and all will be sitting towards, and they will be looking for an application and they'll send you a report. After the complete report is being sent to you, that is when you request for a particular examination, there is a report that is being sent telling that you need to fulfill all these formalities. All these formalities and objections are being fulfilled. After that, clearance has been obtained telling that you have fulfilled all the objectives, and automatically what you get is you get a patent granted. But after the patent is being granted, you will have to wait for 1 month to 1.5 months, looking for if someone is there who is ready for a provocation. That is, who is ready to tell that no, this actually I have filed, he has copied from me or not. That is objections. Okay, so you will be looking for certain provocations, you will be looking for any infringements. Now coming back to my previous slide, I was telling you, the first stage is filing. After that comes publication, correct? Now, once I write the whole information, draft it and send it, that is my provisional patent. It is incomplete. So I'll be given a duration of 12 months of time to submit my complete specification. After complete specification, it takes a lot of time. That is around another 18 months of time to get published. But if you want to publish it at the faster rate, take Form 9, give 2,750 as the DD to Indian Patent Office. It comes under your Indian Patent Journal. After it has been published, you have to ask for request for examination. But nowadays it's become very faster. Okay, previously it used to take 48 months as a standard, and after that 54 months for the exam report, and after that you will be having the 66 month where the patent will be granted. So this is the procedure, but you can pass through it. Instead, what you do is once you file the complete information, okay, along with all the DDs, and once you get the acknowledgement number, then only you can request for your examination. By this, what are you doing is you are saving 1 year of time. So instead of your patent getting granted in 4 years of time, your patent will be granted in 2.5 to 3 years of time, provided you submit request for the examination at the time of submitting your patent document. So you can see here, date of filing, complete specification take 12 months, publishing takes 18 months, 48 months, 54 months, and patent will be granted to 66. So till 66 months you need to wait, correct? So this can be changed, or this can be changed. How it can be done is, if you are filling your early publication Form 9, patent will be published in 1 month of time. So if this is day 0, take 1 month of time. In 30 days or 31 days, your patent gets published. Once you are sending it for publication, at that time only you request for examination by filling Form 18. So you are saving many of months over here. That is, you directly go into first examination report. So this is the strategy that is being followed by so many of the companies. And since they are into service sectors, there are a lot number of competition enhancement which is happening in automobile industry, okay, and other industry, automotive industries. So this is what we completed. I told you what are the forms that are required. Form 1, Form 2, Form 3, Form 9. These are the ones with which you will be giving an abstract. You will be giving introduction, methodology, as well as a particular flow chart, along with the DD of 1,750. Once this has been done, you get an acknowledgement number. Take that particular acknowledgement number, fill Form 9 and Form 18A for examination. Once you're doing that, in another 1.5 months of time, your patent gets published and you will be asked for examination. Okay, once you pay the examination fees, okay, you get objections. Once you clear the objections, then you are ready to take up the then you will be granted patent, and you will be waiting for provocation if someone is ready to go with objections. Oh no, this is my patent, I've already filed, and stuff like that. So if there is no one, automatically that patent is granted for you for 20 years of time. So you can see on my left hand side, this is my student's patent which we had done. It's a fast track vehicle recognition system. Currently it's in examination state. We have corrected with the report. We are filled with all the objections that are being given. We are just waiting with respect to the examination point of view. So you can see what we have done is I've taken an abstract over here. I've just shown it in small terms so that you can people understand. There are the claims telling that what is my model is going to do. I'll have a specification, that is methodology that has been adopted. So along with the DD will be sent to GST Gundi, that is your IPR patent office in Chennai. Okay, and then the formalities will be started up. This is the what I received. It's application number over here. Okay, there's an ordinary application that we have filed. It's not a PCT. I told you if I want to file it in Australia or some other country, this application happens to be ordinary application, comma PCT. Correct, because it has to undergo national phase as well as international phase. Now, date of filing, when we had done, the number of people who have been involved, okay, field of innovation, and you can see here the awaiting request for examination. So during that particular time, we had requested for examination, and currently we have cleared with all the objections. Okay, now I'll just tell you another 10 steps with respect to European patents. No much difference with respect to an Indian patent. It is the same. Fill the application, do with all the formalities, go with all the search, publicize it, check for examination, patent gets granted. Now, after the patent gets granted, there is a validation period where a person has to wait for opposition. Same thing. Once, if an opposition coming to picture, there is something called as a revocation stage. In this particular revocation stage, there is a court hearing that happens in the European court telling that this person has come from opposition. We need some period of time to look for all the formalities, to look for all the documentation. All this is called as revocation stage. And then there is called as an appeal stage where the lawyer from both the sides, they come, they fight, and finally a judgment has been announced. And after that, the patent goes with him. This is the procedure in Europe. But this opposition till here only is a procedure in India. After that, patent goes to the particular person. There is no such a revocation stage where it goes to huge amount of court and other trials and all, and appealing and all. No, this doesn't happen in India. This is the map. Once the application is filed, your journey starts. Once your journey starts, the whole examination objective is being carried out. Yeah. Okay. Now, before I start off with this particular topic, whenever you're filling with the application, there are two things. One is called as inventors and one is called as applicants. Now, applicants are the one who are the main whole and soul of that particular product. Okay. Now, Venkateshwara College has come up with students doing innovative products. Okay. Indian Patent Office have told that all the colleges in India, all the colleges is India, okay, whoever is applying for patent, 50% concession will be given to that college. This is what has been told. 50% of concession will be given in terms of fees, applying fees, publishing fees. They take as invite. One for particular patent. Telling that okay, we want to be inventors. It happens in company also. If you're doing with a particular organization, a particular company, or the head, people, this is what I am saying. Now, going second part, now one that they with innovative ideas leads and innovators. Now, startup and innovation, they go hand in hand. New products and automatic is a constant. Before there was a Nokia phone and to touch. Correct. Likewise, improvisation. So you come up new in you just said your steps to strategize for to identify your IP. That is how you can list down what are the products or services you are entering and what are the intellectual property rights beside. Correct. After you have listed out, since these are and what are the rights that is the first stage that any startup is supposed to do. Identify what is the product, what is the services. Second one is prioritize which. That means you will prioritize which IP to protect, which one has to go with the trademark, which one has to go with patent, or which to go first. Is called as the founders agreement. Okay, so in a particular organization, there'll be two CEOs. or SEO and other laws. Called as a signature for founders agreement. The first person who is employed in that organization, they should have the IP provision in employment contract. And in this contract, it should also have a purpose of what is called as confidentiality. Whatever is being carried out, it should be done in a proper way. And the last one is you need like agreement to be start. You have to identify, make a list, prioritize which to go with, sign. Then whoever employer generate a particular contract which deals with confidentiality, what is the provision, and check the agreement. That's the IP involved over here is you have certain IP consultants and IP advisors who will be working for your firm. So these are third parties. So you should have what is called as non-disclosure agreement to be signed. This is what it says. Yeah. So government has come up with a lot of schemes in order to promote IP and to create awareness of IP. Awareness of IP. So the first thing is Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, Government of India have come up with this particular scheme. Now this particular scheme says SIPP. What does it say is it is going to benefit or these startups in these particular way. One is your IPR facilitators to provide the startups, reduce their fees, okay, provide them end-to-end guidance, and also with respect to the startup application can be expedited. That means faster processing, 70% of time can be reduced. This is what are the benefits that are being given or the schemes that are being promoted with respect to the government. So you have this SIPP scheme that was being introduced by the government, and according to the SIPP scheme, whoever the startup is being registering, there are certain criteria. First thing is the company should be less than 10 years. It should be a private limited or it should be a limited liability partnership company. It should not be a split company. That is, it should not be a division of companies or created out of one other sort of companies, and it should have a scalable business model. So are the candidates have been required to be a startup and to be registered under SIP policy. So as Abraham Lincoln has said, that patent system added the fuel of interest to the fire of genius. Okay, so this is what I want to share. I thank Dr. Shashidhar sir, Dr. Principal, Dr. Nageshwar Gupta sir, Prakash sir, Nirmala Gupta, Purnima ma'am, and Dr. Jijay sir for giving me this opportunity. Okay, and any queries you can ask me. Can you hear me?
Yeah, we are able to hear you, Roshan.
Yeah.
Yeah. Yeah. Yeah.
I'm sorry for the connectivity issue because there are exams going on. So there's a bandwidth issue which is rendering the problem.
Yeah.
So now we will conclude the session. Ma'am, is it okay to conclude?
Ma'am, hello, ma'am. Good morning, sir. This is Manju from DTC department. Sir, I have one query, sir.
Yeah.
Sir, actually, I had to know is the difference in IPR and anti-dumping, sir, in India?
Yeah, there is a lot of difference that is happening. First thing is this anti-dumping what has been introduced, it is with respect to certain software licensing also. Okay.
Yeah.
But in IPR, when you're taking into picture, they are directly software licensing is not being given that much demand because they were falling in the category of copyright. Okay, so basically for software licensing, this has been prepared in India. Right now, this is working.
And I have one doubt, sir. Regarding logo you told us, actually, the recent, the past 1 year before, the Kia has introduced a logo, sir. That is KIA. Again,
Yeah.
after 6 months, again they are introducing another logo, that is different logo with the same names.
Correct.
How the customer is going to identify whether this Kia with the same registered logo is same which is being patented as a original from that company,
Okay, okay.
like Coca-Cola or some Adidas also, sir. I recently like seen around 4 to 5 logos that related to Adidas only. How the customer will find whether it's original with respect to the registered logos?
Okay, I'll tell you an example with respect to my own college. Okay, Ramaya's logo, the previous one, which was being used at 2000 and 2001 and all, and now which has been used. Correct. Now, how will people come to know about it? Okay. Whenever that particular logo was introduced in 2001, that was being registered in trademark registry under class 41. Okay. After a new logo was being introduced, they again went to the trademark registry in order to say that we need to upgrade a particular logo, and they made a new registry. Once the new registry license was being given for this particular logo, automatically they upgraded all their websites and all the services where this logo had to be shown or had to be rendered. So when you told about IKEA logo is being changed, so they need to update their website. They need to update wherever the services they are providing so that people can come to know about it.
Okay, sir. Thank you, sir.
Yeah,
Yeah,
sure.
thanks.
Yeah. Anyone else? Yes, ma'am. I think there's no one.
Sir, another one query, sir. Sorry for interrupt. Sir, the past 2 months before I went to one shop to buy Reebok shoes, sir, actually.
Okay.
Show two types of, that is 2019 related Reebok shoe and 2020 Reebok shoe look, sir. Even I'm confused which I had to buy. So you told there is one particular.
There's a trademark
that,
registry. Yeah, there is a. Yeah. There's a trademark registry.
So how come I believe that whether I had to? Yeah.
Yeah, there. As I was telling you, in the trademark registry, all the new set of logos are to be shown, are to be got licensed, and they are supposed to highlight that then on their website and services. So once you were telling that you had been over there and the logo was upgraded, correct? You need to go again with the website services to check to see whether this logo is existing or whether this product is genuine or not. There are so many products and services which have been still being sold in some other name. So you cannot curb all those things. There are so many things which are existing, correct? So you can get a same copy version of it or a color image of it, and it has been shown with respect to other product and services. Still, it is being used, but curbing all those takes a lot of time, especially in India.
Yeah. Okay.
Yeah. Sure.
Thanks a lot.
Yeah, sure. Anyone else? Madam?
Nirmal ma'am, I think the session has, we have come to the end of the session.
Niranjana ma'am?
Yes, ma'am. I'll conclude it now. Thank you so much, sir, for the knowledgeable event. We had got an idea about the reason and the importance of patenting. It's time to move forward to grab the real gist of this event. Now, I request our beloved Professor Manju sir, Department of E&C, to propose the vote of thanks.
Very good morning. I'm audible to all.
Yes.
Very good morning to all. It's give me immense pleasure to deliver the vote of thanks for this event to all dignitaries assembled here. And I would like to express heartily gratitude to the resource person, Dr. Roshan Jamir Ahmed, Assistant Professor, Department of EC, MSRIT, who honored this event with his inspirational thoughts on IPR and IPR management for startup. will type in no. And like and identify the IPR, how to protect it, and how to prepare the protection and of agreement and the confidence of contract. This and why should we and like that it means, and what punishment will be given if the guidelines is not guidelines is violated, and in of this consideration is that I acknowledge management and the CD sir, Dr. Sridhar sir, for his support in making our event successful. And I would like to thank our principal, Dr. Nageshwara Gupta, and our HOD, Dr. Jijesh JJ, and Dean Academics, Dr. Punima G, and Dean Kama, and volunteers, and our last but not least, our beloved audience for making this event as a grand success. Once again, I thank one and all present here. Thank you.
Thank you, Prakash sir, and thank you, Nirmala ma'am.
It's our pleasure. Roshan sir, thank you very much.
Sure, ma'am.
I think we can wind up the session, ma'am.
Yes, sir. Yes, sir. Yes, sir. Thanks a lot.
Thank you, Roshan. Thank you for the wonderful session. Thank you, one and all.
Yes.